Okay, good. So we got that going. And tell you what, why don't we go ahead? Well, you know what, it's 6 o'clock. Ayana, do we want to give this 2 more minutes or so?
Yeah, I thought we said we'd start at 6:05. I guess I'll give everyone a hello. Thank you everyone for joining us. This is our first program of the year. Many of you completed surveys, and most of you asked for these virtual programs. So we are giving the people what the people want, and this is a virtual program, and I hope that you will find the information insightful. We thank you all panelists, Alice, John, Kate, and Teresa, for making time for this very important and informative conversations, as there have been so many sweeping changes from the NLRB in this Biden administration. And I just hope that we can all walk away with a better understanding of what's to come, predictions, and so forth and so on. So Dean, take it away.
There you go. Thank you. So a couple of housekeeping items. First, we are recording. So just be aware. And everyone is silenced other than the presenters. And if you have any questions, please put them in the Q&A, and we will be doing this contemporaneously. In other words, it doesn't make sense if you ask a question about Cemex or Cemex. We're still figuring out the pronunciation. If we've already moved on 3 cases down, we do have a fairly robust evening planned. We have a wonderful set of speakers. So I will be doing a code at 6:45 and 7:15. Ayana, I've got the suggestions, so I'll be reading them then. Everyone who is on should have the evaluation forms and the materials that were sent out by Lera, by the National Lera, and I would like to thank them. For those who are not aware, National Lera is going to be in New York next summer. We are the host chapter, so you'll be seeing a little bit more about that. So we've got some exciting times ahead of us with this chapter and with the National. So I'm going to ask each one of the speakers, and I'll say your name, and if you could just tell us a little bit about yourself, then I'll do the same, and then I'm going to turn this over. So why don't we start with Teresa Poor?
Hi, everybody. Thank you very much for inviting me to this. I know a number of you, but a number of you I have not met. So Dean and Alice and John and Kate, who we've been working with to give this presentation, thank you for inviting us. I am Teresa Poor. I am the Regional Director from Region 29.
Excellent. John?
Thanks, Dean. Hi, everyone. Like Teresa, I know some of you, and some of you I'm excited to get to know. The Regional Director in Region 2, Manhattan. I've been with the board about 28 years, with stints in Atlanta, Birmingham, Baltimore, and headquarters. And I grew up in the New York area, but I've only been back working here about a year.
All right. Alice?
Hi. I'm of counsel at Bond, Schoeneck & King here in New York City. Prior to that, I was Deputy General Counsel and Acting General Counsel of the National Labor Relations Board between about mid-2018 to the beginning of 2021. I have the distinction of being both the shortest and shortest serving General Counsel of the NLRB. Prior to that, I was a partner of various law firms in New York City, practicing labor and employment law for about 20 years.
Excellent. Kate?
Hi, I'm Kate Swearengen. Nice to meet you. I've been at Cohen, Weiss, and Simon for 12 years. I basically do whatever other people here tell me to do. So a lot of board work, litigation in federal and state courts, some arbitrations, some plaintiff side work, both litigation and also advice and counsel, and once in a while some ERISA work. Welcome.
Welcome. So I'm Dean Burrell. I am a labor and employment arbitrator based in Morristown, New Jersey. Previously was with the Special Litigation Branch of the Board and Region 5 Baltimore, was with a large management firm here. My claim to labor law fame is I was VP of Labor for Republic Services, which owns Allied Waste, which owns BFI. And I came after that case started and I said, get rid of it because it was not a great case. But hey, what did I know? And that's in a few of our outside counsel's children to college. So I would like to say before we go any further, I'd like to thank Bond, Schenck and Price, Alice's firm, for agreeing to serve as our CLE provider. Also, I am Secretary of New York City Lera, formerly President of Arizona Lera, or as I like to put it, all five of us. And I am, as of this weekend, one of the new to soon to be initiated into the National Academy of Arbitrators. So we're still celebrating. So with that said, thank you. I'll turn this over to John. I'm sorry, to Teresa, to John, who's going to kick off Cemex. And after he presents, then we're going to hear from Alice and Kate with some Q&A. Should you have any questions, again, please put your questions in the Q&A, and we will be more than happy to present them. So, John?
Thanks, Dean, and again, good evening, everyone. So just by way of a kind of overview and introduction and wading into this, there's been a number of board decisions in recent months that, they've come out this year, which have revisited precedent. And in order to plan the presentation, we wanted to take the couple, do a deeper dive on those that might be the most unfamiliar to some of us. So I'm going to just give a quick overview of some of the ones we either won't touch on or will do so very briefly. And then I'll contrast that with Cemex and where that goes. But in Atlanta Opera, the board returned the independent contractor standard to what it had been previously. In Lion Elastomers, the board overruled General Motors and returned to Atlantic Steel, another prior precedent. In Wendt Corporation, the board overruled Raytheon and returned to some pre-Raytheon jurisprudence with some wrinkle, and we may talk a bit about that. And in Stericycle, the board overruled Boeing on work rules, and that's another one we may get to some. But the two that we're going to talk about more deeply, Cemex and the one Teresa will address, McComb, rather than being a sort of generally return to something that may be familiar to 5-6 years ago, that precedent that was in effect, maybe with a wrinkle, Cemex really turns the clock back a good bit further and revisits with something new. And this has to do with how unions come to represent employees. So we know that unions may come to represent employees through voluntary recognition or through an NLRB election. And the board's approach developed over initial decades administering the act. But since its 1971 decision in Linden Lumber, the approach was constant until August 25th of this year. So I'll trace the doctrine both in terms of legal principles and kind of how it worked. Going back to the Joy-Silk doctrine, which was in place from 1949 until 1971, then we'll walk through Linden Lumber and to Cemex. So under Joy-Silk, the board permitted employers to refuse requests for recognition if they had a good faith doubt about the union's majority status. And then the board inquired into matters such as whether the employer had committed unfair labor practices to inform whether the asserted doubt was in good faith, with the idea, well, if you're committing unfair labor practices, then you must not have a good faith doubt. Some courts criticized this approach, noting that the one may not really have that much to do with the other. Maybe you totally doubt the union has majority support or any support, but you want to keep it that way, and so you commit violations. On the other hand, an employer may know that everybody is signed up and have no doubt at all, but as long as they don't commit violations, that employer may be able to insist on an election under Joy-Silk. So this was an inquiry into the mindset of the employer, but by reference to evidence that went to something a little bit different, and that was in some ways problematic. So in Linden Lumber, in 1971, the board formally abandoned the Joy-Silk doctrine, and in conjunction with Gissel, announced a new framework that union requests recognition, and the employer, which can recognize if it verifies the majority status, can also say, I believe in elections, go file for an election. And this action would be lawful, permissible, unless the employer committed sufficiently serious and pervasive unfair labor practices to warrant a bargaining order under Gissel. This would require so-called hallmark violations, such as threats of plant closure or discharges. If the employer committed less serious or pervasive unfair labor practices, this might set aside the election, but the result will be a new election, not a bargaining order. So under Cemex, which has been the law since August 25th, if a union requests recognition, the employer must either recognize, assuming it can do so without violating Section 882, and we'll talk a bit more about that as well, or it can file an RM petition. And then we have the employer asking the NLRB for an election instead of sending the union to go ask the board. Now, a failure to do that will result in the employer being obligated to recognize and bargain with the union based on an authorization card majority. But similarly, if the employer commits unfair labor practices that require setting aside the election, the board will dismiss the petition and order bargaining. So in Cemex, the board overruled Linden Lumber, or put it another way, I do think the board retained some of the core principles of Linden Lumber. So first, they're not, as under Joy-Silk, going to inquire about doubt, lack of doubt, good faith of doubt. That's not a part of the Cemex framework. Two, the employer can still insist on an election, but the emphasis is on an election. Not 2 elections, not 4 elections, not 23 elections, an election. You can do this once. And so the principle that an employer can insist on an election, irrespective of good faith doubt, is retained. But if the employer, in so doing, while the election is pending, or while it's getting ready to file the RM, commits unfair labor practices that would be sufficient to set aside the election, then they will be left to recognize the union based on the card majority. So there's a few practical considerations here. I might want to just open this up to dialogue to get into it. But one is what unfair labor practices would meet that standard and which ones would not. Number two is the filing and processing of RM petitions. I think we've seen some in the month and a half since the decision issued, certainly a spike in RM petitions and the interesting interplay of RC and RM petitions regarding the same unit. Also, attention to authenticating cards, which, because Gissel bargaining orders have been so rare, we've seen less of. And then the do they have majority status question and its interplay with 882. So I know we've got both Alice and Kate have some questions in mind, and I can do some wrap up as well. But from that general overview, I think, Alice, were you going to go first, or Kate?
Yeah, I was going to make a few comments from the management side first, and then we'll pose all the questions to you because we're very eager to hear from you. Well, the Cemex decision is a flawed decision for many, many reasons. Key ones, it contravenes core principles of the NLRA, is inconsistent with GISL, and there was just no justification for changing the standard. And I think the practical effects of Cemex will be detrimental to employees, to business operations, and ultimately even to unions. I think the Cemex decision will effectively obliterate the opportunity for large numbers of employees to cast votes in secret ballot elections. And to the extent that elections are conducted, employees will likely be deprived of the opportunity to make actually informed decisions in such elections, because since a single unfair labor practice can result in the dismissal of an election petition, the decision is designed to chill and prevent employers from campaigning or engaging in any activity that might invite an unfair labor practice charge. And this will be especially true if the board agrees with the general counsel's position in TriCast and her captive audience memorandum that virtually any conversation between an employee and a supervisor is inherently coercive and thus an unlawful captive audience meeting. It'll mean that employees will really not be able to obtain information other than from the union that will be helpful to them in making their decisions. And employees will not have the opportunity to vote free of coercion in a secret ballot elections. This will mean that there will be certifications of unions that don't enjoy majority support, and those unions are ineffective and really don't serve the wishes of their constituents. So it's really not good for good and effective employer and employee relations and healthy workplaces and healthy businesses ultimately. And it may ultimately have the unintended effect of delaying recognition and certification of unions, given the potential dire consequences of a ULP finding. I think employers are going to likely litigate the charges rather than settle them. So ultimately, I think Cemex is a really anti-employee, anti-democratic decision. We all know that getting a majority of authorization signatures does not mean that there is actually majority support for a union. We all know that there are oral misrepresentations made and pressure tactics used to get employees to sign authorization cards. And we all know of many elections lost by unions where in the absence of ULPs, where unions assertedly had majority support. The Cemex decision is also inconsistent with GISL, a Supreme Court decision, which repeatedly confirmed that the elections are the preferred method of selecting a bargaining representative, and explicitly recognized the problems with authorization cards that I previously discussed. and thus holds that because elections are the preferred method of selecting a bargaining representative, there must be, as John said, serious or pervasive employer misconduct, and is showing that the misconduct actually affected or will affect the election. A single technical violation of the NLRA, which most employees did not know about or would not have affected the election, would not satisfy Gissel. So the Supreme Court held that the issuance of a bargaining order rather than holding an election should be the exception rather than the rule. Cemex will flip that and make the issuance of a bargaining order the norm, because unless the RD colleagues on the panel say I'm wrong, I think the threshold for issue a bargaining order in Cemex appears to me to be pretty minimal to infinitesimal. And furthermore, the board in Cemex really offered no justification or reasoned explanation for changing the standard. There's no evidence that the current system isn't working. There's no evidence of increased unfair labor practice charges. In fact, the number of unfair labor practice charges relative to representation petitions has gone down, and election petitions filings have gone up. And application of this standard retroactively is also manifestly unjust. So the decision raises many questions on how it will be implemented and how it'll work in practice. And we hope the RDs will be able to elucidate and answer some of those questions. So I turn it over to you, Kate.
Yeah, I'll be quick. I mean, Alice, I'll be frank with you. I disagree with about 99% of that, but I want to, and we talked before, and I'll do my little gloss, but we really want to focus sort of on practitioner concerns and what are the issues facing practitioners. And when Alice and I talk, what are the things we're talking about in our offices? What are our clients' concerns and questions about this process? I will just say very briefly at the beginning, as we all know, the National Labor Relations Act, it came out of the Great Depression. It is not a neutral statute. Its purpose was to correct inequality of bargaining power. How do you do that? You remove impediments to workers acting collectively and forming unions. And from my perspective, at least, Cemex is not a problem unless you have a problem with that basic principle. So I really see this as a positive development. But first question for the RDs, and John alluded to this already in his intro. What are the RD's views as to whether under Cemex, an employer's maintenance of an unlawful work rule after a petition is filed, meaning either kind of petition, an RC or an RM petition, would that justify an order requiring the employer to recognize and bargain without an election, the mere maintenance?
Thanks. Thanks, Kate. So, I mean, interesting what the board has, in Cemex, they've created a new framework, this notion of file an RM, do it within 2 weeks. But as to what does, it's not all unfair labor practice, it's only some, but which ones, rather than purporting to create a new body of law or sort of announcing a standard to be interpreted, the board has said that they will apply a standard that already exists, that we already have existing case law on. So the Cemex board announced that the standard to dismiss the petition and require bargaining is, quote, if the employer commits an unfair labor practice that requires setting aside the election. So this references an existing body of case law the board has already developed, where they were deciding whether to set aside one election. The body of law was developed to see if we would hold a new election, but instead the board has said instead of a new election, and again, as I alluded to earlier, a second or third or fourth or 23rd election, that we're going to go with the majority designation. So here is just a bit of the case law which is developed in that area. So it dates to Dowtex Optical, 137 NLRB 1792, a 1963 decision, and the board said that unfair labor practices occurring during the critical period before an election are a fortiori conduct which interferes with exercise of a free and untrammeled choice in an election. So if it's outside of the critical period, it's either before the election or maybe it's after the election. Our case may be closed and there's determinative challenges and then the employer does something that may be different, but that if it's during the critical period, the notion is that the unfair labor practices tend to be stronger. It's not mutually exclusive, but if it's enough to set aside the election as objection, Dowtex, the board taught that it's probably enough to set, if it's then an unfair labor practice would also probably be enough. So in super thrift markets, this is 233 NLRB 409 in 1977, the board explained that the only recognized exception to this policy, the Dowtex policy, that if it's enough for ULP and it's during the critical period, it's enough to set aside the election, is where the violations are such that it is virtually impossible to conclude that they could have affected the results of the election. So how do we know, is it virtually impossible? So the board looks to a lot of things on this. The number of employees who were exposed to unfair labor practices, the size of the unit, the perpetrator, was it the owner? Was it a low-level supervisor or agent? Is there evidence of dissemination? What was the outcome of the election? How one-sided may it have been? It's a fact-specific inquiry, but the board has waded into this. On the question specifically of a handbook, we may find some guidance from the board's decision in Freund Bacon Company 336 NLRB 847, a 2001 decision. And so there, the only objection was not a ULP allegation, but it was alleged just as an objection, but it was a handbook policy, security, confidential information section, defined proprietary information, that's including all information obtained by employees during the course of their work, and added this manual contains proprietary information. The policy predated the union campaign, so it wasn't retaliatory. It wasn't applied to restrict any union activity, but the majority, and this was members Truesdell and Walsh, found that it was enough to set aside the election, that it restricted or would have been read to restrict employees from discussing information contained in the manual, such as leave policies,
Hey, John,
with one another. Yes, Dean.
John, there was a request that you say the names of the board cases a little more slowly.
More slowly. Okay.
Also, I would point out to our audience that a separate link went out today that has all the materials, all 4 cases that we plan to discuss. So a number of those sites will be in there.
Okay, so I think the seminal case for unfair labor practices are generally thought that they would be enough to set aside the election is Dowtex, super thrift markets, recognized an exception to that it's not a per se rule, but that it would have to be virtually impossible. And then on the handbook in particular, it's Freund, F-R-E-U-N-D, Bacon Company. And there, a manual provision restricting discussion of proprietary information, the board set aside the election and found that was enough. In dissenting, Chairman Hurtgen noted that the policy predated the campaign, that it wasn't discriminatorily motivated, hadn't been applied, And he referenced his dissent in Diamond Walnut Growers that admonished the board for really adopting almost a per se approach. So the direct answer to your question, Kate, is we don't know. We'd have to know what was the handbook provision, what period of time was it in effect, but we know what the analysis is. So I think that's probably as far as we'll be able to go in terms of assessing where it would be. But based on Freund, we can definitely say possibly.
Alice, before we get to your question, I want to interject. John, just to make sure everyone understands, because this decision is major. When putting on my in-house hat, if a union came to me and demanded recognition, I would tell them no. Feel free to. What?
I'm joking. Go ahead.
I'm sorry. I would say feel free to utilize. Remember, I'm a neutral now. I'm very happily neutral. But I would very happily tell them to utilize the board processes. Cemex changes that now. It goes to Joy Silk, which is a 70s case. And now either the employer has to file an RM petition, or, just so I understand, if they wait more than 2 weeks, the board will impose a bargaining order. Is that how it works?
Well, I mean, under your scenario, we don't know if the union really has majority support. So maybe they don't. The board won't impose a bargaining order if there's not actually majority support, but you might be rolling the dice. Because you've sort of waived your right to insist on election machinery and not be bound by the cards if you don't file the RM.
Okay. And I'm sorry, Alice, I didn't mean to cut into your time.
Alice, you're on mute.
You're muted.
No, that's fine. Well, we've kind of gotten ahead, but just for the sake of the order. So based on what you've said, it appears that, and tell me if I'm correct, would the ULP have to be of the type that would actually influence a decision in the election? And again, what if it were the ULP had not been widely disseminated or unknown to most employees? Would that analysis be part of your analysis?
Right. We would look at all of those factors, and one could imagine scenarios where maybe even a very serious unfair labor practice might be said that, well, this can't have affected the results of the election. What if it were a mail ballot election and all the ballots had been mailed, but were in the mail on their way, and then the big ULP happens? I mean, there might be other things to look at there. Potentially, there could be a different wrinkle, but the idea is that it would have to be an unfair labor practice that would require setting aside the election, which would mean that it would have to be one that could potentially affect the outcome. And it's a pretty broad view under Daltex, Super Thrift, some of these other cases I'm talking about, but we do always look at all of the factors. Who said it? Who did they say it to? Who learned about it? Who would have been implicated? What was the outcome of the election? We've already been used to looking at these and assessing, do we set these election results aside and direct a rerun? So it's not really new case law. It's the same case law, but if the answer is, oh, we don't rely on this election, then instead of saying, let's direct a rerun, the question then becomes, was there majority support? And if so, then you move to the bargaining order.
Kate?
Okay.
Next
So
question,
what?
John. So when you were, go ahead, Dean.
Yeah, I've got a question from Louis Di Lorenzo. assume employees, toll card signed to get an election. If an employer does not file, is it automatic union regardless of, I assume, of real majority support? So I assume, okay, think there's a type, assume the employees sign the cards to get an election. If the employer does not file the RM, is there automatically unionized or recognition regardless of the real majority support? I think you answered that, right?
Can you hear me?
Yeah, Louis.
Yeah, let me fill in a word that was missing. You said that you wouldn't order a bargaining order unless there was real majority support. But if cards were obtained by telling people that this is only to get an election, how would you ever find that out?
Well, even so, I mean, the board has done an analysis regarding so-called single-purpose authorization cards. Mm-hmm. So you look at the card to see if it's a dual-purpose card that says, I want to get an election and I want the union to represent me. The general rule is that has not constituted a designation for bargaining order purposes. But if it's a single-purpose card, which says, and unions choose the language to put on their cards, but if it says unambiguously, I authorize union to represent me, the board's teachings say that the fact that someone may have said it's to get an election, or even it's just to get an election, of why they're going to use it, and then maybe it gets used by something else, would not discount the unambiguous statements on the card. I mean, I believe the board has been clear that unless there is a directive that tells employees to disregard the plain language of the card, then they will be held. Their choice will be deemed to be what is written on the unambiguous single-purpose authorization card.
Yeah, I mean, I understand clear meaning, but the card doesn't say, by signing this card, there may not be an election. You're authorizing them to be represented whether there's an election or not. I mean, it just says, I authorize them to be the exclusive representative for purposes of collective bargaining. And it's not all that. Sure I don't think it's all that unambiguous. That the average American worker understands if told by a representative, this is just to get an election.
I'm not sure that changes the Cemex changes that line of cases and that controversy, but it's a great question. One other question that we have, and then I'm sorry, we will turn it back over to the advocates, is what in filing an RM, does the employer have to have a certain number of employee signatures or showing of interest of any kind? I don't think does an employer need just 30? I haven't done one of these in so long. Is it 30% to get an RM, or does there have to be an alleged majority showing first?
The showing of interest, well, if the union has requested recognition, has said we're the representative, there's a majority, then that would be the employer showing of interest. If it's an unrepresented group, if it's a represented group, the showing for an RM, they would need a majority to file for. If it's an incumbent union, but if there is no union, then it would be the demand that's what would constitute the showing of interest.
Okay.
So John, what can an employer do to test the validity of the assertion that the union has majority support, and can the employer ask for evidence of that?
That's an interesting question, and I do anticipate that we will have publicly available guidance in the wake of Cemex and larger decisions like this. Frequently, this general counsel, as has been the practice of other general counsels, will give some of that information. But I do think it's important for practitioners to be aware that a union requesting recognition, they may request recognition based on their belief, but they may have an incorrect understanding of the number of employees that are in the unit or who are still employed there, or something like that. So an employer, before the safe path is you can file an RM and that will resolve it. But maybe the employer is interested to just, resolve this and maybe recognize, maybe start off on the right foot if there's going to be a bargaining relationship. So, stating to a union that, look, I can't recognize without knowing that there's majority support, and maybe frequently the union may say, we represent your employees here, we've got the cards, or otherwise offer. But in terms of what an employer may, certainly they must have something before it's unlawful to recognize. So there's a number of ways that it can come about. Some unions will say, here's the cards, verify them. They may say, well, we want to give this to a neutral. Can we go to FMCS? That card check is a service that they offer, or arbitrators. Dean may want the work to check your cards, or one of our other neutrals here. I see several others in the group, maybe a former NLRB regional director. But there's options available to, other than through an RM, find that out. But exactly what that would be really the conversation with the union and the employer.
What does it look like, or what should a union advocate tell the union in terms of if the region wants to do an investigation into the validity of cards? And for example, you're dealing with a very economically marginalized workforce, or maybe a workforce comprised of undocumented workers. Should the union be instructing workers that you may have to go in and talk to an agent of the federal government and say, that's my signature? I don't know if there's guidance on this, or maybe something from the Gissel context, but.
Right. I mean, I think that, and we've found this, as there are a few of these pending in our region, and as we move forward on deciding them, some of them were cases that were already in gestation before the Cemex decision that we would have analyzed under the Gissel framework, and now we're going to analyze under the Cemex framework. And Gissels were pretty rare. And so not every, and maybe at one time they were more common, but not everybody is accustomed to the really kind of a large lift that it is to authenticate 300 cards. So one thing certainly that unions can do is be thinking, sort of reversing the procedure. If we're going to be bringing these to the board because possibly the employer will commit an unfair labor practice, or they don't file an RM petition, there's going to have to be some way to authenticate. So the board has recognized a number of ways for authentication. The card signer's testimony certainly will do it. Also, the testimony of the card solicitor, the testimony of somebody who's familiar with the card signer, the signature of the card signer, the testimony of someone who witnessed the signing, signature or handwriting comparison. So sometimes organizers will sort of initial or countersign cards so that you're not later on just like, oh, here's 300 cards. Which ones did you get, 2 months ago or 3 months ago? And so the notion that there's some kind of a record that we can, through 4 organizers, authenticate the 300 cards that came in, or you can, is something that may save not only whatever concerns people may have about talking to the labor board, but furthermore, it's just a lot less effort for our team, or Teresa's team, or whoever, or Suzanne's team to to resolve that. Another point here to think about in the context of an immigrant workforce is that that is not something. Immigration or work authorization status is not something in this sort of a context that the labor board is interested in, would not ask about, would advise, would tell people don't proactively get into this. But that's not what this engagement with the government is about. There's also a program, and Teresa, you may jump in if you remember more of the details just to share, but there's a process by which, if there are immigration concerns in connection with an NLRB case, an R case, or a C case, there's the protocol to ask for certification of that, which would go to it would go to the prospect of adverse immigration actions being forestalled in terms of our
Yeah.
partners in immigration, their enforcement procedures. Teresa, did you want to jump in with more on that?
Yeah, the terms, so there's
Suzanne.
deconfliction and deferred action so that somebody gets work authorization. But deconfliction is a relationship that we have with ICE, where if there's a threat to bring in ICE, we can work with DHS to get them to stand down, because there shouldn't be no conflict between labor law and immigration law. The two should be working together. So employers shouldn't be using ICE as a way to undermine labor law, is the basic idea. And then deferred action would be U visas and lining up for U visas and us in support of U visas to compel witness testimony. That's what I got.
Thank you, Teresa. I'm going to jump in as the moderator. I'm going to ask if Kate and Alice, if you don't mind, I'm going to ask John to touch on one point that he briefly alluded to, which kind of intrigued me. And if you could just do that in a minute or two, and then I need to read the first code and move on to the next case. Unfortunately, we could spend like 2 hours on just Cemex. This is great stuff. So my question, which you touched on, John, is if the employer files the RM, does that not allow them to describe the unit and then start the parties down an extended unit proceeding?
So, I mean, interestingly, we've had a number of circumstances where an RC is filed. I wondered if Cemex was going to put us out of the RC business, but it hasn't so far. That we would just have unions requesting recognition and not filing for elections, but we've continued to have filing for elections. But then what happens is, in a number of cases, the employer turns around, well, they filed too. So now we have an RC and an RM, and what we have done is consolidate them either for hearing or a single stipulated election agreement. There's also the prospect of holding the RM in abeyance to resolve the RC, but that way the employer's met there. Okay, I've filed an RM, and we may get some more guidance from the board or the general counsel about this. But interestingly, because of the notion that if you commit a violation, we're going to dismiss the petition and order bargaining based on the cards. The notion that an employer, as I think some have expected was the case, well, an employer may want to have a protracted time before the election to have an education campaign. It may be reversed, because it's that amount of time for an education campaign is also some more time that someone might commit an unfair labor practice, whether they sort of, are trying to toe the line and they fall over it, or they just wander into it, or someone walks them, craftily into it. And now they have this. So the notion that an employer that, we may think they might want more time is not necessarily so. But it does also put it on the employer to say, okay, here's the bargaining unit that we want, here's where it is, and it sort of begins that process and gets it going.
Okay, thank you, because I think that's to me, as soon as I saw Cemex, I said, yeah, that's going to start some interesting things. First CLE code is NLRB 0764. Okay, and with that, Teresa, I'm going to turn it over to you to tell us about McLaren, which is another fascinating case which the board just issued.
Thanks, Dean. Hi, everybody. I want to give a tip of the hat or a shout out to the NLRBers in the room first. Hi, John. Dan Silverman, the person who hired me. Eric Brooks, the person who trained me. And Suzanne Sullivan, my colleague. So shout out to the NLRBers. Hey, Dan, it's been a while. How are you?
Congratulations, Teresa. It's well deserved.
Thank you. Well, we'll see. You can tell me how I do. So I'm tasked with presenting on McLaren-McComb, which is not nearly as meaty and as exciting as Cemex, but perhaps it probably has more impact on day-to-day operations, employment relation operations, severance agreements. So McLaren-McComb is all about severance agreements. And most employers will have a severance agreement tool in their toolkit. So McLaren-McComb in this board overturns a few items on severance agreements. But before I get into it, what I'm going to do is give you the posture of the case, tell you about where some guidance is, if you haven't seen it already, lay out some of the basic facts of the case, discuss the ruling, and then open it up for a hazing from Kate and Alice, which will be great, and anybody else who wants to jump in. So the posture of this case is, this is a Region 7 case that came in about 2021, 2020. It made its way through an ALJ, and obviously the board issued its decision on February 21st, 2023. It is currently pending enforcement in the Sixth Circuit. So this one is still live, but the board has weighed in. If you need further guidance, the GC issued a memo on March 22nd, 2023. It's a memo that's public, and it's set up as a Q&A. So I highly recommend that you find this GC memo. I think it's, 2308. So go look for that one, and it'll give you board cases and answer many of the questions that I'm sure a lot of you have. So let me just tell you the basic facts of this case, and then I'll talk about the severance language. The basic facts of this case, when it got to the board, it came up as an 8A5 and a 1. It was an employer who's dealing with COVID in an employment relationship of a newly certified union. So it's a new bargaining situation and COVID. Challenging for any employer, I am sure. So as the employer is adjusting to the new situations, the employer starts to furlough people who may not be needed to deal with COVID issues. So they furlough, I'm not going to give you the details of the employer, but it's public. They furlough 11 permanent furloughs. But the problem was that they didn't give the union notice and an opportunity to bargain. So really at the start of this case, the heart of it was an 8A5. But what was the notice and opportunity to bargain about? It was about a severance agreement. So the employer offered a severance agreement to each individual permanently employed employee, and there were about 11 of them. So it arrives and it comes up to the board, and the main part of the board's case that is of interest to us here is how it deals with the severance agreement. So let me tell you a little bit about the language that the board considered in the severance agreement. I won't quote it entirely, but there was a confidentiality clause and there was a non-disclosure clause. So the confidentiality clause was asking employees to not share the terms of the severance agreement with anybody except for their wife and their accountant. Or their spouse. I think it was spouse and the accountant. And the other part was a non-disclosure language, which prohibited employees from making any statement that would harm the image of the employer. And the audience was employees of the employer and the public. And the employer was defined as the employer, the parent company, and any of its affiliates. So don't harm the image of the employer by trying to speak with employees of the employer or the public, and the employer is defined broadly. So the case comes up, the ALJ makes a finding of a violation of 8A5, which the board upholds, but decides that the severance agreement itself did not violate 8A1. And in making this finding, the ALJ applied two board cases that I'll refer to as Baylor and ISG. We'll make sure that you all have the board case law, or you can go to GC memo. You can get the citations there.
That GC memo is in the materials.
Okay, great. So the ALJ applies the board cases I'll refer to as Baylor and ISG. And it comes up to the board. The board, like I said, affirms the 8A5 finding, but decides to find a violation, that the severance agreement violates 8A1, and overturns Baylor and ISG. So what is it about Baylor and ISG that this McLaren board found to be problematic? The first part is that this McLaren board decided that the Baylor and ISG board were approaching a severance agreement in the wrong way. So the first thing that the Baylor board does is it approaches a severance agreement and decides that it's not like a rules case, right? If it's not like a rules case, then there is no coercion. So a severance agreement has a lot more voluntary move to it. So if an employer offers a severance agreement to an employee, well, the employee has a voluntary, it's a voluntary deal. The employee can say yes or no to it. There's no coercion that gets trucked in because it's not like a rules case. And if it's not like a rules case, then you've got to figure out, well, if you're going to analyze a severance agreement, then you've got to kind of look at the context of it. And the context matters for a Baylor and an ISG approach. So are there other violations here? Was this employee discharged in violation of ULP? So as a ULP. So animus and motivation is a factor that a Baylor and an ISG board analysis would require. So the McLaren board comes in and says, and pumps the brakes and says, no, don't do it that way. And it pumps the brakes by reminding, I'm just going to put the two boards in dialogue here, by reminding the Baylor and the ISG board that an 8A1 analysis doesn't require animus. It doesn't require effect, right? So if to find an 8A1 violation, you just require the board and its expertise to decide whether like this would chill or this violates or this is an unfair use of employer power in the employment relationship. So it kind of relies on, so animus and did it work? Did it have the chilling effect? Those variables do not matter in the analysis. So the context, which the Baylor board said is critical to finding whether a severance agreement violates the act. The McLaren board says, now context doesn't matter. It's an 8A1, don't do this. But the McLaren board does another thing, is it kind of turns back to, the McLaren board turns back to the Baylor board and reminds the Baylor board of the broad sort of scope of Section 7 activity and the heart of the National Labor Relations Act, which is like an imbalance of power. And so it reminds us that that employees have the right, even if they're not employed, to talk to employees. They have the right to use various channels to complain, and broad severance agreements that chill that right, strike at the very heart of the National Labor Relations Board. So they do two things. They remind the Baylor board that 8A1 doesn't require any of that, and then they undermine the assumption of the Baylor board, which is this is a severance case. It's voluntary, not a rules case. And they come in and say, no, there's still an imbalance of power. There's still a power relationship in a severance agreement. So they kind of like come in that way. So then what's the finding? Like what's the rub here for practitioners? The rub here for practitioners is that a severance agreement when the board and when your region approaches a severance agreement case, we will analyze the language of the case without regard to the context. So severance language that is very, very broad, that prohibits employees from speaking or from acting about working conditions will likely be kind of an unlawful severance agreement. It's the broad nature that prohibits that ability to reach out. That is my short statement on McLaren McComb. I open it up to the hazing.
And again, this case has some huge implications.
It does. As a person who would love to get a severance agreement if I get laid off, it is a fantastic tool that employers can have. It's a benefit. And I think what the board and general counsel is saying is don't do them, just tailor them appropriately.
Exactly. Kate?
I agree. I want to preface this by saying I love the decision. I especially love the kind of clarifying memo the GC did after it came out. But when I represent individual plaintiffs in separation agreements, it is a huge pain because I try to, employers love the word disparage. They do not want to make that more narrow. The GC says in her memo that non-disparagement provisions may be permissible if they're narrowly tailored to, quote, employee statements about the employee statements about the employee that meet the definition of defamation as being maliciously untrue, which is defamation is maliciously untrue is obviously, something distinct from disparagement. And I convey to employers, no, this language you're proposing is inconsistent with the NLRB decision that came out this summer. And for your information, here's the case and here's the memo. And it is very difficult. And I think part of the reason is the employer knows that even if the employee signs an agreement, they still have the right to file a charge with the NLRB. So they think, well, what's the harm? We'll put this language in here. It may be unlawful. So what? So they'll file a charge and there'll be a notice posting. But, more often of the time, this will intimidate the employee. The employee will say, I better not breach this. I better be very, very careful about what I say. Because there'll be another provision in the agreement saying that if you breach the agreement, you're going to go to court and the employer is going to be entitled to some sort of damages in the event of a breach. And it's cold comfort to tell the employee, well, the NLRB thinks this is unlawful and you can file a charge with them. They're more worried about the prospect of having to defend themselves in court. One more piece is I'm seeing language like this, not in separation agreements also, but when an employee is hired at an organization, they will be made to sign a confidentiality agreement or kind of a modified non-disclosure agreement that will contain language that's very similar about the employer's goodwill and the importance of the employer's goodwill. And you don't want to do anything or talk about anything that might damage that goodwill. So I'm wondering if this case might also have application, not just in the separation context, but in the employment context as well, where the individual is still working.
Yeah, I think I don't have the number off the top of my head. I have it in my notes somewhere and I'll put it in chat, but GC just issued a memo indicating that the analysis that is the McLaren analysis to severance can be like trucked in and used to apply for like non-competes and employment used to apply it to at the point of hire type of contracts.
That's great.
Yeah.
And by the way, and I don't want to divert us from what we're discussing, but the FTC currently has rules that are pending regarding non-competes, and the general counsel has put that solidly in her sights. So you will see some future programming from New York City Lera on that topic. So I apologize. Teresa, I turn it back to you.
Oh, no, I'm opening it up to Kate and Alice. Have at it.
Well,
the hazing begins.
Okay, well, of course, I think that this was an opinion in search of a problem. The case could have been decided under Baylor because of the fact that it was not negotiated with the union, not presented to the union. And so I think that I think it's still an open question, even under McLaren-McComb, as to whether a union can negotiate this kind of an agreement on behalf of employees, or perhaps an attorney, because the board was concerned that the employees were handed this agreement without representation when they were in a vulnerable position. And after all, isn't that what unions and attorneys do all the time? They horse trade for valuable consideration. Also, I think the general counsel's memo in a number of ways goes beyond the decision of McLaren-McComb. For instance, the decision really dealt with a confidentiality provision concerning the terms of the agreement. It did not hold unlawful the other confidentiality provision concerning proprietary information and confidential information. And in the GC memo, she's saying that those provisions are unlawful. So that's really beyond the actual decision. So one of my questions is, are you issuing complaints on those provisions that were really not held unlawful under McLaren-McComb? The other thing is that the GC memo asks what, in her view, the unlikely event, the employees request a broad confidentiality or non-disparagement clause. And her answer is it would still be unlawful to proffer such clauses because the board protects public rights that cannot be waived in a manner that prevents future exercise regardless of who initially raised the issue. And I would say, and there is no citation, no decision citation for that quote. The board in McLaren-McComb did not go that far and made no mention of public rights, only rights of employees themselves. So to me, this is conjured out of thin air. And as I said before, seems to contradict NLRA precedent, and which permits unions to bargain such clauses.
Well, and let me Teresa, I think those are important questions. I'd also like for you to answer, what can the parties do now? Because the board doesn't issue model language. You look at case law and say, okay, this was allowed, that was not allowed, and then you just copy what was allowed. So I think Alice really hits the nail on the head. And what is permitted now? What can, when I go and help the party settle a case as a mediator, what can be in that settlement agreement?
Right. Let me start by answering these really good sort of questions about how do we apply this, and is GC's memo providing guidance kind of like stretching too far, right? I guess we'll find that out in the Sixth Circuit. But so let me go practical, and then I'm going to go broad. So the practical matter is, if you look at GC's memo, in translating this, which is the directives given to the regions on how to deal with these issues, it appears to me that the basic guidance that is given over and over again without being like very detailed is to narrowly tailor a severance agreement, to narrowly tailor prohibitions on speech, on action, on what employees, once released from your employment, can do, can say, and can do. Make it narrow. And there was a really interesting footnote that I think GC's memo refers to in the board decision, a footnote, I think it was 47. But the question was, why does the employer need this severance agreement? So it kind of like switches it back on the employer. And maybe as practitioners, Kate, I think you mentioned this, it's like, how do you even deal with this? The question is, what is it that you're trying to protect yourself from? You know, is it like, you know, don't dox my mom? Okay, you know, maybe that could be put in the severance agreement, but is it don't complain? I think one of the questions that were given to us prior to is, can you prohibit discussion about the product itself, right? So a prohibition on I think, Kate, that was your question to me prior to today's meeting. Can an employer prohibit speaking about the product itself or speaking about the service that the employer provides? That would seem to be a decent prohibition as long as it limits it to just the product and service, not the terms and conditions that produce the product and the service. So it'll be like, I'm basically telling all of the lawyers and practitioners here is you have a robust employment world around you now, because you will be crafting narrow severance agreements that like prohibit speaking about that without actually speaking about the terms and conditions of employment, right? So the right is to be able to talk about terms and conditions of employment. So that's kind of the general idea. I don't have any more specific guidance rather than to speak with your clients and ask them why they need it and what they're aiming at and just craft it narrowly. That seemed to be, John, is anybody, any RDs or it just, that seems to be the best advice to give is to narrowly craft it.
I think that's right.
Okay.
What about a phrase, and I'm thinking about this because I negotiated an agreement today where the parties have a mutual non-disparagement agreement. The individual will not disparage the company and the company will not disparage the individual. Does that mean that, and I know obviously you can't, you know, bless or not bless something, but the individual will not disparage the company other than feeling free to discuss terms and conditions of employment? I mean, I don't know what works now.
That's hard because I mean the inherent, you know, power between the individual and the company. If I'm angry and I go on Glassdoor and I write a review saying this is a terrible place to work, I was mistreated, I was underpaid, versus the employer who can really, you know, badmouth the former employee and make their prospects of landing a new job very difficult.
Right.
I don't know the answer. I mean, but yeah.
I mean, that's the context it usually comes up in, where an employee is concerned about disparagement and wants a mutual, you know,
Right.
agreement.
Right.
Yeah.
Or to Teresa's point, maybe you just limit it to the products.
I think the dialogue, I think having a dialogue with the people, the person who's gonna, you know, usually it's the employer's tool to offer. They've already laid off the employee's gone, right? So I just need you to behave in a certain way once you go, right? So the question is like, what is the behavior you're trying to limit? I think that is what practitioners need to have, like a conversation to make sure that the disparagement isn't like disparagement about terms and conditions of employment that they like to talk about.
So
Perhaps.
right now, when you do a settlement agreement, you carve out, there's numerous things that you carve out, usually workers' comp, NLRA. I know there's some cases where every now and then an employer will try to not carve out the board, and you know, then that leads to some issues. So yeah, I'm just not sure what that looks like. So I think from my standpoint now, where I help the parties craft settlement agreements, that's created a certain level of consternation because like I said, I'm literally doing one today, and
Yeah.
Neither one of them are traditional labor lawyers. Do I say anything?
I don't know, Dean. I can't answer that one. Good luck.
Yeah.
I think just use these as like guides,
Right.
and think narrow and have that conversation. But Alice brought something up that I don't think GC's memo addresses. besides the position that GC memos like goes beyond the decision. Like I said, Sixth Circuit can decide that. But what if a union trades, like bargained on behalf of these 11 workers to trade away certain rights? And as we know, unions frequently trade away fundamental rights to get something, right? So obviously the no strike, no lockout for a grievance procedure, that's the heart and soul of collective bargaining. That's usually in most contracts. I think, Kate, you mentioned this while thinking about a severance agreement negotiation between a single employee and the employer. And there's a little bit, it changes when it's the union representing a group of employees. So that's the whole heart of the National Labor Relations Act. You bring in a union to balance the scales of power, and then maybe the waiver that was once coercive is no longer coercive. I don't think GC memo goes there, and I'm not sure what the answer to that is, Alice. Hopefully I'll get that answer one day, but I think that is to be developed. And the other part is
kind of brings
go ahead,
up,
Dean.
I'm sorry, and
No,
I'm
go ahead.
putting back on my board hat, even though I haven't had it on in a while. You know, the whole Milwaukee Spring was concerted. You know, that raises some issues there. Tell you what, I'm going to read.
If I might, so you, Teresa, you don't really see any difference between like, you know, like a broadly given severance agreement versus an individually negotiated settlement agreement?
Yeah, that actually goes to, I think, one of your bigger questions, which is where in the text, where in the decision is this broad public interest that GC mentions in her memo. And I actually think the board mentions it too, over and over again, in McLaren. So on that broad issue, and they actually point to it. They refer to the text of Section 1 of the Act, which sort of sets forth the sort of policy reason, the public's interest. And it is in Section 1, I'm not going to quote it verbatim here, but it goes like this. Experience shows that employers get to associate, and they have like a sort of more power than individual employees. Individual employees aren't able to associate like employers, so that'd be labor history. You know, you get to be a corporation, but employees don't get to be in a union, and that strikes at the very heart of the liberty of contract. So Section 1 says in order to have full rights of association and actual liberty of contract, I think that's the quote, full rights of association, actual liberty of contract, the public has an interest in balancing the scales. And then in the McLaren-Cohen decision, they point to, for the purpose of public interest, I think they point to a couple of cases. One is a U.S. Supreme Court case. What is it? National Licorice. Other people can, but I think that it stands for the sort of GC and the board are putting they're staking their claim on what the heart of the National Labor Relations Act is about. So to answer the question, Alice, yes, GC and the board would see a difference in an employee negotiating a severance agreement and a collective interest like a union negotiating it.
Cool. Tell you what, let me go ahead and read the second and final code, which is NLRB 0579. And we've got about 10 minutes left. So Teresa, why don't you tell us, we've gotten past, I think, the two sexiest cases that have come out. Stericycle, which seems to be kind of that Republican board, Democratic board.
John has taken Stericycle. I got Went, and we'll have no
Can I
time for Went.
interrupt you?
So go,
There was a
John.
question in the chat. Can I read the chat question?
Of course.
From Ayana, before we move on, from my understanding, the non-disparagement and confidentiality does not apply to managers. How do they define managers and those exempt from this decision?
Okay, so what was it? So, obviously managers and supervisors do not have the protection of the act. In GC's memo, there's a brief discussion, like basically the McLaren decision applies to managers and supervisors. The circumstance would be something like this. So you can give this severance agreement to managers and supervisors and like make them not talk in a way that harms the employer. They're not covered. But
Right.
if you ask a manager or a supervisor to give an unlawful severance agreement to an employee, then perhaps that manager or supervisor refuses to do it and then they get fired. So a lot of like little things have to happen before we would consider
Kind of
how
the
this
Rob
impacts them.
Chevrolet.
Yeah, how this would
Yeah.
impact a manager or supervisor.
I'm reading the question as how does one know who is a manager versus who is not?
That's exactly it. We have
okay.
quasi management roles, and we, wonder, are they, covered, or do we have to get rid of those clauses?
Okay, so how do you know? So for supervisors, I know the questions on managers, but for supervisors, you have section 211, so that will define that. The act doesn't define managers, but there is a body of jurisprudence that goes through it, and so I think that they're essentially borrowing, as we talked about in Cemex, the managerial standard, and we recently looked at this in detail, but I think you have to trace the management case law to determine, are these folks managers under the NLRA or they're not.
Yeah, that's what I was thinking, that it's the same supervisor standard and jurisprudence. Yeah.
No, but there's two different standards. The supervisory standard is easier because it's defined in the statute. But certain managers are also supervisors, but you can be a manager without being a supervisor. But the board has, certainly in the R case realm, but probably in the C case realm as well, articulated are some people who are managers, for example, are excluded from, they don't have a community of interest, or they may not even be employees who are they're excluded, but it's a lengthy, there's a good bit of jurisprudence on it. It's maybe tougher to trace than just the 211 supervisory status, but it is a different standard.
Isn't there some 8A2 case law there that came up a few years ago, probably about 10 plus? I remember revising some job descriptions because of those concerns a while back. Teresa? Yeah. Oh, no.
No. We've got 7 minutes left. John Doyle's got Stericycle, but perhaps just keep it open. I don't think we're going to get to the two other cases, Stericycle and Wendt.
Right.
Yeah. Sorry, I took over your MC position. No, Dean, wrong.
It's okay. Everybody does. Okay. Yeah, why don't we just kind of scratch this, unless there's any other questions, do we want to just scratch the surface on Stericycle and call it a day?
Sure.
Yep, John?
Go ahead.
All right, I'll wade into Stericycle. So Stericycle deals with rules. And the board revisited its teachings in Boeing, which itself revisited its teachings in Lutheran Heritage, can be traced to Lafayette Park Hotel, and all of these are just the more recent several turns. The reasonable tendency of a rule or an admonition is something about which board members, board decisions have disagreed, and so there may be, a rule which, for example, civility rules, employees should be civil to one another, and an employee may take that to mean we don't do things like, swear at each other or throw things or spit. Someone else may feel like, well, if I say this is a dirty, rotten employer, because they haven't paid me for 6 weeks and I'm still working, well, now am I going to be violating the civility rule? I don't know what it means. And so the notion that there's not just one reasonable interpretation, there may be several reasonable interpretations. And if one of the reasonable interpretations would chill an employee from exercising Section 7 rights, is that unlawful if a different, also reasonable interpretation might not? And whereas in Boeing, the board looked to sort of more, was less willing to sort of draw inferences on what someone hypothetically might read into something, and try to distill it to more of a kind of a direct meaning. In Stericycle, the board strikes a different balance, and like the other cases we've talked about, this is a three-member, three of the members of the board voting to overrule precedent. That's the practice of the board, is not to go back and forth on 2-to-1 panels, or even majorities of the board members. And so there's a little bit of a wrinkle from Lutheran Heritage, or at least some emphasis. So the board says that also in Boeing, the board was weighing the employer interests, and the Stericycle board questions, well, how do you factor those in? And so the standard, as under Lutheran Heritage, requires the general counsel to prove that a challenge rule has a reasonable tendency to chill employees from exercising their Section 7 rights. And here they clarify that we interpret the rule from the perspective of an employee who is subject to the rule and economically dependent on the employer, and who also contemplates engaging in protected concerted activity. So that's kind of the starting point. Not whether would you read this and the first thing you would think is, oh, is there something I can't do? That may not be the first thing that comes into your mind. That this is viewed from the perspective of somebody who's thinking about engaging in protected concerted activity, but their rent is paid, their groceries are bought with their paycheck from their employer, and so they're wanting to make sure that they're not jeopardizing that. And so the perspective of the employee in that particular situation in Stericycle is, I mean, I think probably the maybe the most significant distinction from the Lutheran Heritage standard that had existed before. We don't have a lot of Stericycle cases yet, but the board has been interpreting and applying Lutheran Heritage, was doing that for a long time before, or for some period of time before Boeing came up. And certainly there seemed to be a lot of handbook cases, and we continue to get them in Boeing, and we'll continue to have them now. But that's kind of an overview of the board's change in assessing work rules. And I think one of it parlays well with our earlier discussion about Cemex, because the prospect that a rule that may be a bit esoteric, maybe this isn't the first thing you think of, but it's how a reasonable employee who's preparing to engage in protected concerted activity and is economically dependent on their employer might reasonably read the rule. Is this something that, again, going to some of the questions that Alice and Kate raised, could be the violation that commits an employer to a bargaining order rather than an election.
Excellent. Oh, Eric Brooks has put out a chat.
There you go, Eric.
Yeah, outline of law and representation.
The managerial case law. All right.
Yeah, that was the Bible back when I was there. It still is. Any final comments from Alice and Kate on this case?
I was just going to say, it's reading tea leaves a little bit, but when you've seen these cases in the past on handbooks, have they been standalone charges, or have they been kind of omnibus charges? And one of the allegations is just the handbook. And second question is, do you anticipate now with Cemex that unions or employees will be kind of holding these cases, and waiting until there's a demand for recognition or a petition?
Good one.
So to the first question, it's been a variety. It may be that someone actually is discharged, maybe the discharge isn't lawful, but we get looking at the rules and someone files a charge about it. I don't think there's a lot of employees that, get their handbook and go home and start researching the case law to see if, is there something in there. Usually sort of stumbles on it. There may be a union organizing campaign and some violations, and the union will go through it and ask about those. So direct answer, it's a variety of ways. Now, on the second question, I'm not sure I follow. Maybe you can unpack about the notion that they might sit on a
Do
handbook.
you think it's more likely now that
Right.
that unions are tuned into this because of Cemex and say, oh, great, this is great. I hope they don't modify anything before we make the demand for recognition.
Because
or
we can rely on this.
Kind of a stealth, yeah.
Well, actually, it goes to a question that I didn't have time to ask on Cemex, which is, how can a work rule that was, promulgated years ago be the basis of a ULP for Cemex purposes if presumably the union obtained majority support, notwithstanding the existence of this unlawful work rule.
So to Kate's question first, you sure would hope that people wouldn't want to sit on something unlawful to try to use it. I'm reminded of pine tar incident where somebody watched an unlawfully pine tarred bat and waited until it was important to raise it against George Brett when he hit a game-winning home run. But people will use it as they wish, I think, and we'll see it. I don't know how that weighs in the analysis, or how it will weigh. To Alice's question, I think that this Freund baking decision gives us some indication that board members may view a rule predating an organizing campaign and still in effect as grounds for setting aside the election. And if it's also, it wasn't alleged in Freund baking, but if it's also alleged as an unfair labor practice, then the four corners of Cemex seem to suggest that it would be enough. And in terms of, well, how could that be? Is it impossible? That's another part of the analysis, but it might be that a union reaches majority status, but doesn't continue to campaign thereafter in the lead up to the election in ways that they might lawfully could, because employees are inhibited by a work rule. And somebody doesn't come to vote and they lose the election, or leaves and goes to another job. So I don't know that even though the majority status was obtained while the rule was already in effect, and it was still in effect, is enough to say that the majority designation isn't the more reliable indicator. I think it would be something that the board would want to consider, but it's an interesting question.
It is. And boy, we could, again, just when we think this stuff is cut and dried and they're just going back and forth, Repubs and Dems, maybe not. So tell you what, I am going to thank everyone, Teresa, John, Kate, Alice. This was wonderful. This was fun. If we do this is just great stuff. And to everyone, thank you so much for joining. We had over 40 folks on this program, and you will see us in November. We will be delivering full programming throughout the year. So everyone, thank you so much. It is truly appreciated. Good night.
Thank you.
Thanks, everyone.
Good night.
Bye.
Oh. It's John.